Ready, start. We may note here that we had called upon the parties to explore the possibility of amicable settlement. Stop. The parties could not arrive at an amicable settlement. Stop. However, during the course of submissions, it was accepted that the appellants had brought a purchaser who was willing to purchase the said apartment at the cost of rupees 2.85 crores. Stop. The learned senior counsel, appearing for the respondent company, stated that considering the fact that the third appellant is a member of the bar, the respondent company is prepared to give up a sum of approximately rupees 30 lakhs still payable by the appellants and transfer the said apartment to the purchaser brought by the appellants. Stop. In the alternative, the learned senior counsel, appearing for the respondent company, stated that by giving up the claim to receive the amount of approximately rupees 30 lakhs payable by the appellants, the respondent company is willing to put the appellants in possession of the said apartment, which is ready for possession. Stop. However, this offer was not accepted by the appellants, who are still insisting on getting a refund of the amount paid by them with interest. Stop. Therefore, the parties could not arrive at an amicable settlement. Stop para. The third appellant, who is an advocate, has made submissions on behalf of the appellants. Stop. He submitted that as there was a gross delay on the part of the respondent company in completing the construction of the apartment earlier booked by the third appellant, the appellants had no choice but to accept the offer given by the respondent company in respect of the allotment of the said apartment. Stop. Relying upon the correspondence made from time to time and photographs placed on record, the third appellant submitted that the entire balance consideration in respect of the said apartment was paid by the appellants by 31st December 2016, and therefore the respondent company was under an obligation to complete the said apartment in all respects within 45 days from 31st December 2016 and put the appellants in possession thereof. Stop. He pointed out that though the appellants repeatedly protested by addressing communications to the respondent company that the construction of the apartment was incomplete, no steps were taken by the respondent company to complete the work. Stop. Moreover, the appellants were forced to pay certain amounts towards social club subscription and the maintenance advance, though no facilities were in existence. Stop. He pointed out that after granting enough opportunities to the respondent company to complete the work in the apartment on 21st September 2017, the complaint was filed by the appellants. Stop. The third appellant also pointed out that the earlier consideration amount paid by the appellants towards the booking of the apartment in Garden Isles was not transferred by the respondent company towards the consideration of the said apartment. Stop para. The third appellant, appearing in person, pointed out that the conduct of the respondent company is fraudulent, as without furnishing even a copy of the standard terms and conditions of the allotment, signatures of the appellants were taken on the last page of the terms and conditions. Stop. He submitted that therefore clause 9.5a in the standard terms and conditions will not be binding on the appellants. Stop. Hence, the argument of the respondent company that the grace period of 3 months was available to it after the expiry of 24 months from the date of the letter of allotment, is without any foundation and ought not to have been accepted by the National Commission. The third appellant also pointed out the terms and conditions of the quadripartite agreement dated 9th December 2016, to which the appellants, the said bank, and the respondent company were parties.